Karen, just to be clear, you didn't do it.
We know who did it, Steve. We know. And we know who spearheaded this cover-up. You all know.
Yes, we do.
If John was beaten up and attacked in that house, who did it?
We don't know.
We don't know.
We don't know. And it's not for us to know. Somebody other than Karen is responsible for that, for the killing of John.
Yeah. Roberta in the truth zone, mic hitting raw. Spotlight shining, she exposing the flaw. Debunking the myth, breaking their facade. This is Glass City, respect the squad. On these NYC blocks where the skyline flex big. Roberta Glass slicing lies with a truth rig. Innocence frosters, your stories unravel. She's a map through the madness of gritty gravel. Glass don't bend and facts don't break. She's a storm that's called, you feel the quake. Exposing tales stitched with crooked seams. Justice in the lens, shattered fake dreams. Dreams about killers, painted heroes in disguise. She burning propaganda with fire in her eyes. No glamour for the guilty, she call it straight. She backs victims, the voice stay awake. Stats and receipts, no spin, no clutter. Cold cases whisper, she cuts through the mutter. Truth's her tempo, don't confuse the beat. She's standing for the real while you taking a seat. True crime's a block, facts the artillery. Spinning those lies, yo, she checks that misery. Tabloid tales get smashed, no time to play. She's glass hard, break the false and save the day. True crime's a block, facts the artillery. Spinning those lies, yo, she checks that misery. Tabloid tales get smashed, no time.
Okay. How is everyone? Hello, B Rabbit. Hello, Myrna. Hello, Lucy. Hello, Angela. Thank you, Maestro, for moderating and always doing such a good job. Jennifer Ray, my happy place. So what a day it was in court. So talking about today, two things happened. I mean, two big things, I put to two separate categories. First off, Ian Whiffen, always such an excellent witness, took the stand, but this time his testimony was much more extensive. And Hank Brennan is using the cell phone to really prove his point and to disprove the innocence fraud campaign started by Karen Reed and her lawyers, Alan Jackson and David Yannetti, that Jennifer McCabe Googled, searched. This is what the defense's strategy was, to say, look at this weird Google search at 2:07 a.m. in the morning. What is this about? Why was Jennifer McCabe searching House Long to Die in the Cold? Clearly, it was because she was involved in a murder and she had witnessed police officers throwing out John O'Keefe onto their front lawn, as seasoned police officers are known to do when they want to hide the body. But Ian Whiffen, again, I mean, every time we see this testimony, Jessica Hyde also echoed this testimony last year, that the search was done not at 2:07 a.m., that it's an open browser, not a search timestamp. So it's the time that the browser that you used to do the search was open, not the time that you did the search. I have so many open browsers on my phone. I don't know what McNasty Green, Karen Reed's digital forensics expert, would think if he looked at my phone. I mean, I keep so many open browsers on my phone. So that the search was done instead at 6:23 and 6:24 a.m., as Jennifer McCabe honestly testified, because Karen Reed asked her to do it. And if you look at the behavior of Karen Reed, this is something that she did. There was no need to involve Jennifer McCabe or Carrie Roberts. Why didn't she go searching for John on her own? Well, she knew where he was. She was the only one who knew that morning that something terrible, causing death. She's the only one who knew John was dead, that something terrible had happened to him, and she knew right where he was. She's an amazing psychic, that Karen Reed. And right where to find him, too, when no one else could see him buried in the snow. Karen Reed leapt out of the car and went right to him. And so instead of calling 911, she got Jennifer McCabe to call 911. Instead of calling Jennifer McCabe, she got John's niece to call Jennifer McCabe. She does these things by proxy, just as she did her murder by proxy, using her car so she could have probable deniability. Just call it an accident. I didn't mean to do it. And there's still some people on this side who still think that Karen Reed didn't mean to do it, even though her foot was 75% down, 74.5, I'm rounding up, percent on the gas pedal. So the immense pressure near flooring it, going 24 miles an hour in reverse. And she seemed to know that she had clipped him. So I think she did it on purpose. All those things tell us she did it on purpose, with her infotainment system beeping and flashing at her, telling her she's about to hit something. She knew she did it on purpose as a way to teach John a lesson, and left him there knowing he was seriously injured and would die in the cold, but she didn't care. It was an ultimate exercise of her power. Also, Ian Whiffen testified that John O'Keefe never left the flagpole area. I was hearing some people today talk about, it's the fire hydrant. He may have hit the fire hydrant. I think that what Hank Brennan is going to argue in this is that the wound on John O'Keefe's back of his head was caused by hitting Karen Reed's spoiler on her car. The piece of near the top of the hood that sticks out. So when he was thrown back on it, which makes a lot more sense than the hard ground, but either or could have happened. I guess it's just we can't know exactly how it went down, even with all these experts. We can't know. We just cannot know what caused all these wounds, although we have a pretty good idea that he was carrying a glass. The wounds on his arm were caused by hitting the side of the car and being torn apart by her broken, smashed to smithereens taillight. Also, so his body never left the flagpole area. Also, we know that his phone had facial recognition, and that the last time he looked at his phone and it opened was when Jennifer McCabe texted him. He's out of the car. You know that because of the car data and the seatbelts, when his seatbelt was released, that he was walking and he looked at his phone and put it back in his pocket. And that's the last time it was opened. Now, of course, Robert Alessi, ridiculously, I thought this was the most ridiculous part of his cross, suggested that someone else could have been set up on his phone with facial recognition. I don't know one person in my real life who has this. And I'm not talking about people with kids who want their kids to be able to open their cell phone. I mean, I can't open my boyfriend's cell phone. He can't open mine. I mean, it's a little bit of a privacy issue. I wouldn't want to set it up so his face opens my cell phone. I mean, the only person that John O'Keefe would do that to possibly, and I think it's unlikely, is Karen Reed. So unless you're saying Karen Reed is last looking at his phone as she's looking over him before she sped away, when she said, I took a look at him and he didn't look mortally wounded. So clear that that's about that night, not the next morning. That you're going to say that she opened up his phone. I mean, it just implicates her. You're going to say he set it up for Brian Higgins. He set it up for someone else. Come on. Jennifer McCabe. We would set it up for Jennifer McCabe. I mean, that's absurd. And so all those things were really powerful. I felt really powerful testimony. I heard the jury was very invested and interested by those who were in the courtroom and seemed to get it. It was really well explained and easy to follow, as it was last year. He's an excellent witness. Jessica Hyde is too. I don't know if she's coming in as well. Wouldn't think so. This seems to be a very pared down presentation by the Commonwealth this time, as is normally done in presentations. Second time around retrials, you pare it down. You find out what worked the first time, what didn't work, and how to present it to the jury in the shortest, most effective, most powerful way you can. So secondly, what I predicted happened, although Hank Brennan didn't have any, he didn't have any kind of shock material, but it was a shocker of a voir dire this afternoon. The ARCCA witnesses are just absolutely hired guns for the defense, beholden to the defense, will not hand over any of their communications. What it told me was that they were communicating not only with the defense, but with Karen Reed herself, because, spoiler alert, Daniel Wolfe testified that he was talking via an encrypted app, Signal. When an encrypted app means that it's very hard to get the actual material, the actual content. You can download it, but it's difficult. And on Signal, you can set it so that it auto-deletes. So I don't even know if the FBI can get that material after it auto-deletes. But why talk if it's such a professional relationship? Why are you talking on Signal? Why are you saying you deleted your text messages? This is not normal for an expert. You'd want to keep your text messages. You'd want to keep all communication so that you had a record of it. If there was something, there wasn't a kind of, what do you call it? Collusion going on. Also, on the witness stand, this was the other shocker. Daniel Wolfe testified that, and so did Andrew Rentschler, the two ARCCA witnesses. Now, these are accident reconstructionist witnesses. So they were the ones who came in who said, we got all the information we needed we were hired by the federal investigation. We weren't paid for by the defense. Lo and behold, it turns out that we didn't talk to the defense. We met them for the first time in court, and the defense said the same thing. We never talked to these witnesses before in our lives. There were lots of back and forth emails from them before they testified, talking about the voir dire, scripting their testimony together of what they were going to say in trial to convince the jury to help get Karen Reed off. So also he testified that they were given information, he said, by the feds. I would think it would be the defense, but maybe it was the feds. But they were given information while they were sequestered and not supposed to watch the trial of what the other witnesses were saying for the Commonwealth. So you do that so that their testimony is untainted by what the Commonwealth says. They're supposed to be independent witnesses, not hired guns for the defense. And there they are testifying that they're getting information in order to counter it about what the other experts are saying in the trial. I mean, again, this defense is so criminal, and it's all coming in. Big spoiler alert. Judge Kearney already approved it, and they have to get a report in of their new testing that they've done for the defense in by May 7th. But as Hank Brennan has said before, he's been asking for this information since November, and the Commonwealth will have to do without all these communications that they deleted. Like, okay, it's okay that the defense cheated. Tough, big tough for the Commonwealth. That's basically the message from Judge Kearney. She's going to do everything she can to help the Karen Read get off and get away with her cop killing, her murder. That's the message I got. But also, during cross-examination by Robert Alessi, Wolfe said that he was being harassed, that pictures of his kids, because people felt that he committed perjury. Now, I found that I tend to not think that the harassment would come from our side, but if it did, I couldn't have been too upset about it. But because people will get upset if you perjure yourself, stand, commit perjury, lie under oath. But I'm questioning myself if this is even true, because he's the one who put it out that he had kids, and his wife joined the Karen Read Facebook group right after Free Karen Read Facebook group the day he testified. In February 2025, Wolfe says he spoke to Jackson about hate emails he was receiving impacting his family. Pictures of his children were put out on the internet. This impacted his wife. He was concerned, also spoke about pending motions to exclude ARCCA testimony. But his wife put out pictures of herself and her children on Facebook. It was public. All this was public. People weren't finding private information. This was all public. They put it out. So if you don't know, here's Dana Wolfe, his kids. And here's Dana Wolfe, who joined the Free Karen Read Facebook group only after he testified. So, they're fully they are hired guns for the defense. Certainly not the independent witnesses that was proven. Let's take a look at the testimony, shall we?
Parties are present, the jury is not present.
All right, thank you. All right, so we know that the Commonwealth has filed a few anyway, or repeated motions trying to get the defense to comply with reciprocal discovery regarding the ARCCA witnesses. Previously, about a month or so ago, maybe longer, I found that there was a violation of the defendant's obligations for reciprocal.
This has been asked for. This is, again, too little too late. The voir dire is too little too late. Letting them come in is just insane, I think. But I don't think it will matter much. I think Hank Brennan will destroy them in cross. And I hope he hustles. I don't know. I hope he finds an expert who can help him and can hustle with this report. I don't know.
Discovery, and I found that it was deliberate. The Commonwealth filed additional motion, a motion to compel reciprocal discovery of the ARCCA witnesses or to exclude their testimonies. Upon that, I believe, I issued an order last week for certain discovery to be provided and to be provided by ARCCA. On the day of opening statements, it was clear to me that there was another violation of the defendant's rules, defendant's obligations under our rules of criminal procedure. And based on that, especially given what the defense has failed to deliver, I would not permit the defense from mentioning ARCCA in their opening. So today we're going to have an evidentiary hearing on your motion, Mr. Brennan. So I expect that we will get through both witnesses by the end of today. If not, we'll have to have them.
Okay, I guess I'm confusing everyone in the chat. No, Patricia, no, the Commonwealth would never, Karen Read will never plead out, even if the Commonwealth offered her a deal. She'll never, ever plead out, ever. Ever. It'll never happen. If she gets convicted of even the puniest of charges in this case, she will be fighting it. H. Lowe, go back to my episode last night. I made the case. There is a big rivalry between the Attorney General's office and the DA's office. I went through it all last night. Go check it out. So they said the feds were just feeding them information knowing they were sequestered. How did the U.S. Attorney's Office not know that the witnesses were sequestered in the Karen Read trial? How did I know and the Attorney General's office not know? You tell me. Except to cheat to win, which is the name of the game for the defense.
I expect we can get through them. So, Mr. Brennan, who are we going with first? Dr. Wolfe?
Please.
Okay.
Face the clerk and raise your right hand. You solemnly swear that the testimony you shall give to the court in the matter now in hearing shall be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Thank you. All right, go right ahead, Mr.
Thank you.
Brennan.
Good afternoon, doctor.
Good afternoon.
Did you become aware there was an order from this court to produce records?
Yes.
Did you receive a copy of that order?
Yes.
Who did you receive a copy of that
So we
order?
need Dr. Wolfe to identify himself.
Please identify yourself for the record. Spell your last name.
Daniel Wolfe, last name spelled Wolfe.
Who did you receive that order from?
I believe it was in an email forwarded from Miss Little.
Did you read it?
Yes.
Did you understand that there was a request for certain communications?
Yes.
Did you understand that you were supposed to turn those records over to the Superior Court?
Yes.
Did you turn records over to the Superior Court?
I provided a copy of that production notice to Miss Little.
Did you provide the records to the Superior Court?
I didn't directly email that to the court, no.
Did you indirectly email it to the court?
It was my understanding that it would be passed along to the court.
So you did not, pursuant to the order, provide the records to the Superior Court, did you?
Not directly to the court, no.
When you read the order, you understood what the order was requiring you to provide, correct?
Correct.
It was requiring you to provide all text messages.
Yes.
Did you provide all text messages?
I don't have any in my possession.
Did you look for any text messages that are not in your possession about this case?
Yes.
Okay. Did you find any?
No, sir.
What did you do to look?
So I went through the phone that I presently have, and as I informed Miss Little, last year I was under T-Mobile, was my carrier. Subsequent to that, I then switched to Verizon in, I believe it was November. So I made an effort to contact T-Mobile as well as get access to my T-Mobile account hub. Unfortunately, I was unable to get access to it or get any records prior to, or at least from my T-Mobile carrier. Then I went through my Verizon records that I have from 2025. I could only go back 3 months, and I provided those records.
How about emails? You didn't change email carriers, did you?
No.
Didn't change email carriers. Another bit of Hank Brennan's dry humor. So I switched phone carriers. I still have my phone. All my text messages still exist on my phone. Are we to believe that Daniel Wolfe from ARCCA destroyed his phones? And if he destroyed his phone, was he part of a murder?
No, sir.
Did you provide all your emails from when you first were contacted by the defense?
Yes, sir.
And you provided every one of those emails to who?
To it would have been in the file that I put together for the production.
How many emails did you find between you and the defense?
I'd have to look at the order, but it was probably 6 to. Are you talking about present day or just from last year?
Anytime.
It was probably around a dozen or so.
Who did you correspond with by email on the defense?
Again, can you specify a time frame?
At any time. Who did you correspond with by email on the defense?
It would have been Mr. Jackson. Miss Little might have been on one of those emails. There might have been a couple other members. I don't remember off the top of my head.
Well, how about Ms. Reed?
I don't believe she was on any of those emails.
You've never emailed or been on a correspondence with her by email?
No, sir.
And how about Mr. Yannetti?
He may have been on one of the emails. I don't know as I sit here today.
You communicated by phone with the defense, didn't you?
Yes.
And that began as far back as March 2024?
After our report was issued, yes, in March.
Right. So I'm speeding this up a little bit just to make it through as much of his testimony as I can. But this is what a lying witness looks like. We already know that he has no problem lying under oath. He's been caught lying under oath before. And this is, again, he's lying under oath, I believe. My opinion. I think it was obvious to everyone in the chat he was lying. He's defensive when he shouldn't be. He over-explains. And he smiles as he lies. He's a dark character, another one of these dark personalities that's attached themselves to this murderer. Now, I don't think the real relationship between Alan Jackson, David Yannetti, and ARCCA is ever going to come out. But it seemed to me, this is what I gathered from it, is that Karen Reed was on all these chats. She's really running her defense. And she insisted that they talked via Signal. That's Karen Reed's favorite way of communicating. That's the way she communicated with Aidan Kearney on the Signal app. And she asked the intermediary, Natalie Bernschneider-Wiki, to download Signal the same way she asked Daniel Wolfe to download Signal app. And this is so irregular for a expert witness to be communicating via a Signal, an encrypted app. This is the way criminals and substance dealers to communicate via these encrypted apps. It's such a problem. Go look up encrypted apps and criminal activity. I mean, I'm sure I've so many articles about how it's an epidemic among criminals using these encrypted apps. Switching out cell phones.
Back in March of 2024, you spoke on the phone to Mr. Jackson
Yes, sir.
a number of times.
Yes, sir.
And as you spoke, you began to become familiar with him and his role in this case, didn't you?
We corresponded about, again, our expected testimony here at trial. Yes.
I'll ask it again. Did you become familiar with him and his role in this case when you spoke to him?
I understood him to be the defense attorney on the case. Yes.
Did you speak to Ms. Little?
Fredo says he uses Signal all the time, but you're not an expert witness in a case. This is highly irregular for a expert witness in a trial. They keep all the communications. They know they have to keep communications if they're going to testify in a trial. They know they have to hand them over for discovery. The fact that we had a voir dire is punishment for not turning over something. If the Commonwealth did this, the free Karen Readers would never stop screaming. And Karen Reed's case could have been dismissed. We're already in trial. They haven't handed over discovery. Just the way Alec Baldwin's case was dismissed when there was anything that could be considered exculpatory, and that they usually have a very, very, very wide view, courts do, of what could be exculpatory. That's hidden from the defense is considered a Brady violation. Now, the reason that the defense is doing this is so that they can sandbag and ambush the Commonwealth in trial.
Little by phone.
I don't believe so, no.
Did you speak to anybody?
Hold on 1 second, please. Thank you.
Did you speak, pardon me, did you speak to anybody other than Mr. Jackson about this case before the first trial?
I don't believe so, no.
Did you speak to anybody since then on
Yes.
the defense team? Who?
I believe Miss Little and Mr. Alessi.
Okay, and how about Ms. Reed?
No, sir.
Did you ever have any conversations that weren't on a regular telephone? You ever Zoom?
Yes, we have had, I believe it was a Zoom or a Teams meeting. We've had a couple.
When was that?
That would have been more recently to go over some of the testing that we've done.
Did you ever have any Zoom meetings before the first trial?
No, sir.
Did you ever have any group conferences before the first trial?
I don't believe so, no.
Were you ever on the phone before the first trial in a conversation where you and Dr. Rentschler both were on the call?
There may have been an instance of that. I just don't recall.
Oh, think back.
I don't recall.
At some point, you were contacted by Mr. Jackson and you decided or you learned that you may be part of this case as far as a witness?
Yes, sir.
When you learned you were part of this case, did you have contact with Mr. Jackson before you testified at the voir dire?
Did I have communications with him?
Yes.
Yes.
And in those communications, you spoke about your role?
I think we spoke about logistics and coordinating my arrival here for the voir dire and certainly the trial.
But when you spoke on March 20th, 2024, didn't you talk about more than coordination of logistics?
I'm sorry, what was the date?
March 20th, 2024?
So I believe that would have been the very first phone call that I had with Mr. Jackson.
Right. Was that more than about logistics?
Well, I think we were trying to figure out what should we do. I will note that this was a very abnormal situation for me, being involved in a federal investigation and then ultimately being called as a witness. Well, I'm trying to answer your question.
But you're not. Did you talk about more than logistics?
So are you finished with your answer, Dr. Wolfe, or are you still answering?
I was still trying to answer.
Go ahead, finish.
Thank you. So as I mentioned, again, the situation was abnormal. I didn't know if we could get involved. I didn't think Mr. Jackson knew we could get involved. In terms of a path forward, would we be able to do more work? Could we review additional material? How could we work together moving forward? There was a lot of unknown, so there was a lot of uncertainty.
You done?
Yes, sir.
Did you talk about more than just logistics?
No, sir.
Did you talk about fees or structures?
I described to him our typical procedure when we intake a criminal defense case, right? There's typically a contract and retainer associated with that. So I described our normal procedure that takes place. Yes.
So you talked about fees and scheduling and costs, what you charge.
I did talk about, yes, the contract and the retention letter.
When you talked about that contract, there was a discussion, wasn't there, about them hiring you, paying you, or retaining you?
Potentially, again, I prescribed our standard procedure.
Why wasn't you talking about fees and schedules if you didn't think that you were potentially going to get hired?
Again, I prescribed our normal operating procedure. I had no idea how it was going to work moving forward, which is why ultimately, immediately after that phone call, I contacted the Department of Justice to get clarification on that.
We'll get to that, but I'm asking you specifically, why were you talking about fees and scheduling and being paid at that point?
Objection, Your Honor. I'm going to allow it.
Again, because Mr. Jackson was interested, I believe, in calling us to testify at trial. So I explained to us the normal process. When a client reaches out and wants to engage us for trial testimony, that's typically, again, the procedure that we prescribe at ARCCA. So that's why I had that explanation to him.
So you were talking to him about details about potentially being hired. Isn't that fair to say?
I don't know about being hired. I think, again, him utilizing us in the trial as expert witnesses.
Well, what's the difference between him utilizing you and paying you for that utilization and him actually hiring you? What's the difference in your mind?
Well, I think there is a difference because ultimately, after I got clarification from the Department of Justice, they indicated that they could not, the defense that has signed any type of contract, there could not be any type of agreement or retainer.
I'm not asking what you determined later. I'm talking about the conversation you had on March 20th, 2022, when you were speaking to Attorney Jackson. That's what I'm talking about, okay? Understand?
I don't know that I understand your question then.
Okay. When you had a conversation on March 20th, 2022 with Attorney Jackson, you discussed potentially being hired, paid, compensated by Attorney Jackson or the defense for this case, didn't you?
We did, like I said, I did explain to him our typical operating procedure when a client reaches out for trial testimony. I went over that with him, yes.
I'm not talking about a client, I'm talking about this client. Did you talk about them potentially hiring or retaining you for work in this case? That's the question I'm asking you on March 20th, 2022, not the 22nd, not the 24th. March 20th, 2024. Did you speak to Attorney Jackson about them potentially retaining or hiring you for this case?
I spoke to him like I speak to any other client that would be interested in calling us as a witness.
Okay. And so after you spoke to them, you spoke to representatives of the United States Attorney's Office, and you wrote an email back saying that you're going to put the conversation on hold. Is that fair to say?
Correct, until I got clarification from them.
At some point it was on hold, right? At some point it resumed.
Yes.
When was that?
That would have been towards, I believe, the end of April.
The end of April. How was this relationship resumed? What was the contact, the conversation between you and anybody on the defense that resumed that?
Right. So this was the big part of Alessi's argument when they got caught communicating, is they said there's a big pause. When the Fed said they couldn't talk, they didn't talk. There was a big pause. They were totally independent. Come on. And then Judge Cannoni asked, well, were they paid? Yes, they were paid $23,925. They're still pretending like they didn't set up any payment or what they were going to get paid. And even though they were retained, and he didn't save any of his communications, but he tracked every minute of what he did, because that's how you get paid. You get paid by the hour, of course. And the only way he would know how to get paid by the hour, he says he's on staff at ARCCA, so he doesn't get paid by the hour, but ARCCA bills by the hour as their expert witnesses. So he would have to keep track of his time. And he's like, well, I just normally keep track of my time so they know. And he loves to, and he referred to himself in the third person, the douchiest move ever. So Dr. Wolfe, Make sure you know that I have a PhD. Knows what they're doing that week. I mean, very defensive, not direct, didn't answer the questions honestly. And his answers were extremely hard to believe if you live on planet Earth.
Relationship.
I think that I reached out to Mr. Jackson. Like I said, I think it looks like about a month had passed. And I had let him know that I had spoken to the DOJ and got clarification on moving forward.
So in April of 2024, you reached out to the defense and said that you had permission or a green light to move forward in the relationship with the defense in this case.
I had clarification from the Department of Justice, yes.
And that clarification allowed you then to work with the defense on this case.
Not work with, we could be called on the defense's behalf to testify. And for that matter, the Commonwealth could have also contacted us and utilized us at trial as well, if they should, please.
So when did you become an advocate for the defense?
Interesting.
Do you feel like you're an advocate for the defense?
No, sir.
Are you sure about that?
Sir, I'm on the science and the analysis that I've done. That's the side that I'm on.
You sure are. Because after that 424 call, letting them know that the United States Attorney's Office gave permission for you to be called as a witness, you called them again that day, didn't you? Or they called you on the main line?
We may have exchanged a couple calls that day, yes.
Well, you did exchange a couple calls that day because we have at least some records.
A couple calls. In fact, we did exchange a couple calls. Oh, you're on the side. You're on the side of the science, all right? We're this great. This is some of the best cross-examination I've seen. My time covering trials. I'm going to take a quick break. When we get back, more of Daniel Wolfe's unbiased, totally independent testimony. Don't go anywhere.
Mic check, Roberta strides through the static haze. True crime Gotham where the shadows play their plays. Fraudsters fold when a spotlight beams. Fact focused queen busting propaganda schemes. Glass shatter lies echoes through the streets. Standing for victims, giving voice their beats. NYC post, truth sharp as night. Roberta exposing she's the anti-fraud light. Hard task warrior, dissecting state and defense. Twisted innocence, claims breaking pretense. Gotham's truth seeker cuts clean with the blade. Facts in the forefront, no justice gets swayed. Cold facts drip heavy, real talk unfurls. Cracking cases open like oysters with pearls. Innocence gimmicks crumble to dust in the wind. For victims, her creed, justice till the end. Headphones blazing, she drops heavy artillery. Narratives twisted, meet blunt object civility. Roberta got receipts that unravel the ploy, exposing the lies these fraudsters deploy. Glass shatters lies, echoes through the streets. Standing for victims, giving voice their beats. NYC Post, truth sharp as night. Roberta exposing she's the anti-fraud light.
Okay, we are back. More with Andrew Rentschler. Here we go.
And when you called later that day, after telling them that you had permission, they could use you as witnesses, what did you talk about?
My apologies, Daniel Wolfe. I don't know why I said that's the other ARCCA guy. That's the other ARCCA guy. It's Daniel Wolfe. Here we go.
Do you have the records that I could take a look at just so I could see what you're referring
Do you
to?
remember having calls after you called Attorney Jackson and said you had the green light from the U.S. Attorney's Office? Do you remember having further calls that day?
I think we had a couple brief conversations, yes.
Okay. When you think about it, do you remember them, or are you just saying you think but you don't know?
I don't remember. I remember that there was one conversation, I believe in early May, that I had with Mr. Jackson in which we engaged in a conversation where I gave him more information about my background, who ARCCA was as a whole. I think we even got stuck a little bit about my family, my 4 kids and things of that nature, but it was a call about background and qualifications.
We're still back in April. You're moving ahead to May when you first started going. I want to talk about back in April. Do you remember having conversations on April 24th with Mr. Jackson? Do you remember that?
I'm going to allow that.
I remember that there were conversations, yes, specifically what they were too. I remember, I think they were brief, but I don't remember the specifics of them, no.
Well, in the brief conversation, what do you briefly remember about that brief conversation, Doctor?
Well, as I mentioned, I think I had finally received clarification from the DOJ, so I think I was letting him know that I had received that clarification.
Sir, you said that was the first call. There were more than one call. There was then 2 calls to the main line. What did you discuss with him during those calls?
Well, to be honest with you, the call to the ARCCA main line, I don't even know if I spoke with him. That's just to the main line, not to me directly. So he could have spoken to a receptionist who then tried to get a hold of me, right? So I don't know if that specific call to the main line was to me or someone else at ARCCA.
Well, this is a new relationship, right? You're working on a contract with the federal government. You have only spoken to Mr. Jackson, according to you, twice. You don't remember the early conversations with them and what they were about?
I'm sorry, are we talking about now at the end of April
Yeah,
still?
I'm still talking at April. April 24, 2024.
Yeah, as I just discussed with you, from what I recall, it was relaying to him the clarification that I got from the Department of Justice.
Right, but that doesn't take more than one call, does it?
This is like very, very teenager-ish, tantrum-ish behavior, tantruming on the witness stand. Like I just told you, getting an attitude with Hank Brennan, not a good look. He will be pushed in trial. What a psycho. Enjoy your blood money. Daniel Wolfe, enjoy it.
Does it?
I don't know. He may have been in court. There might have been some phone tag. I don't know, sir.
Well, there was a 9-minute call on April 24th, and then there's 2 calls to the ARCCA main line, 3 minutes and 2 minutes. Do you remember any of those calls?
Again, when you say 3 minutes and 2 minutes, that makes it sound like, in all likelihood, he contacted the ARCCA main line, got a hold of a receptionist or my project manager, and couldn't get a hold of.
People were saying he reminds you of Wolf of Wall Street. You know who he reminds me of? He reminds me of American Psycho, that character.
Me.
Are you just making that up, or that's what happened?
Sir, that is my best guess. I don't recall from a year ago.
We're not asking you to guess. I'm asking for your testimony.
That's what I recall, sir.
You recall him calling a secretary on the main line? That's what you recall?
He very well could have. I just don't know, sir.
But you're making a representation that you recall him using a secretary in the main line. I'm asking what you actually did and actually said. Do you remember speaking to Mr. Jackson, Mr. Jackson or anybody on the defense team after that initial call back on April 24, 2024? Do you remember those 2 phone calls?
Objection, Your Honor. So let's get an answer.
I don't remember those phone calls specifically. No, sir.
Next
Do you
question.
remember the phone call on April 30th, 2024? Do you remember that one?
I don't remember that call, sir.
Do you remember the call on May 1st, 2024?
I don't have the records in front of me, but was that a longer call by any chance?
It was 40 minutes long.
Okay.
Yep.
So then, yes, as I just described earlier, that would have been the call in which I went over with Mr. Jackson a little bit more about ARCCA, my background, my education,
Dr. Wolfe, did you have an issue with putting a kitten in an ATM? Daniel Wolfe, did you show off your business cards to your fellow ARCCA staff members?
qualification, the kind of casework that I do, things of that nature.
And did you discuss issues regarding this case?
No, sir.
So during the 40 minutes you spoke, you never discussed any of your findings that had already been made.
No, sir.
You had never discussed any of your testing in this case during that 40-minute conversation.
No, sir. And it was all laid out in the report that was issued in
I
February.
understand the report. I'm asking you, did you have any conversations about it with the defense?
No, sir.
So in that 40-minute conversation, you talked about your family.
See, honest witnesses don't have to get defensive like this. And I believe that Alessi, like he did with all these witnesses, scripted his testimony. And as it's falling apart, Alessi's objecting and objecting to no avail.
Past times, ARCCA, but never ever talked about this case.
Objection, Your Honor. I'm going to allow it.
Correct.
You billed for that time, didn't you?
I believe that I kept track of that time, yes.
Okay. When you kept track of the time, did you submit that time and ultimately get money for that time?
Again, I routinely keep track of my time when I'm working on a project. So yes, that time was kept track.
That's not what I'm asking you. Ultimately, that time that you kept track of, did you then submit it and get paid and compensated for that time? That's what I'm asking you.
Well, first off, I'm a salaried employee, so I don't get direct compensation when an invoice goes out. That invoice, when it's sent, ultimately comes back to ARCCA. That doesn't come back to Dan Wolfe.
Okay. So in order to get paid for that, you would have had to submit that time through ARCCA to then forward it, wouldn't you?
Oh, why do people do that? Why do they refer to themselves in the third person? It's so cringe. Every time. It's awful. Like, just makes me... You're referring to yourself in the third person? It's such a turnoff. It's, ugh. Yuck. And he's going to be really angry when he loses the rest of that hair.
Are we going to allow it? Is that true?
Yes. I keep track of my time so that my boss knows what I'm doing. Yes.
Okay.
Who asked me that? Yes. Come on over.
All right, let me move through this.
Doctor, again, to focus you, we're on May 1st, 2024. May 1st, 2024, you had a conversation with Attorney Jackson.
Correct.
And at some point, did you submit the time you spent and forwarded it so that could be billed?
Yes, and I will note that all of that time was actually tracked under the same project number that the work that was done for the Department of Justice was under.
So at the time you had that conversation, you were keeping track of hours, correct?
Something I routinely do, yes.
And do you know who ultimately paid that bill for that day, May 1st, 2024?
I know now that it was the defense, yes.
Now, when you billed, did you bill for the entire conversation?
I don't know.
You said most of the conversation was background, talking about ARCCA, talking about your families.
Yes.
Do you typically bill?
He doesn't know who's going to pay him when he bills. Give me a break. I mean, this is so unbelievable.
Spending time talking about families?
Again, that wasn't the entirety of the conversation. I think he just briefly asked me about my family.
Oh, now it's brief. Okay.
Objection, Your Honor. No comments, please.
Do you typically charge when you're talking about non-related work matters in your billing?
Sir, I think the majority of that phone call was related to, again, work-related topics.
Work-related, it took that much time to talk about ARCCA?
And my background, certainly.
Yeah, okay. And how much was the majority?
Sir, I don't know that I can parse it out in individual segments or minutes for you.
Certainly. I can tell you my background in about 5 minutes or less. Apparently, this takes up a whole conversation. No, way less. 2 minutes or less. They're talking about their kids. Give me a break. I can't wait for him. They're going to be so impotent, these witnesses, by the time they come on the stand for Karen Reed. It's really not going to make a difference.
And so after that May 1st conversation, did you communicate with the defense before June 9, 2024?
I don't believe so. I think from what I recall, next up was, I think, the voir dire. Either Alan, I think Alan contacted me, letting me know that the court wanted to do a voir dire of myself and Dr. Rentschler.
You mean Alan, you mean Attorney Jackson?
Yes, sir.
Okay, so you became friendly.
I guess first name basis, is that what you're referring
No,
to?
I'm saying, did you become friendly?
No, I wouldn't say that we were friends.
I didn't ask if you're friends. I said, did you become friendly?
I talked to him like I talked to all of the attorneys that I work with, sir.
What would you call me if you were going to address me?
Probably Mr. Brennan.
Yeah. So, do you remember the next time you spoke to Alan?
As I mentioned, it probably would have been sometime in early or mid-June.
Probably Mr. Brennan, but right now I'm going to do sir as I lie, as my face turns beet red with a smile on my face. Since I'm such a practiced liar, I've learned how to smile and lie at the same time. And chew gum, probably. You could probably smile, lie, and chew gum all at the same time. It just offends me. It's kind of people that move through life lying and smiling and dressing well and hiding deep deception and having and making money doing totally immoral things.
Going into June, you were keeping track of all your communications with Attorney Jackson or anybody from the defense, weren't you?
I don't know if you mean, what do you mean by keeping track?
Well, do you have a folder where you make notes when you have communications with an attorney and discuss issues?
No, sir.
You don't make notes?
Not for brief phone calls, no.
For your billing, do you save phone records or text messages so you have some collateral evidence about the billing?
No, not when it's things about, again, logistics and traveling and scheduling. No, sir.
By the way, when you put together your phone records and text messages that you sent to the court in response to the court order, did you have actual records?
What do you mean in terms of actual records?
Well, I see like a summary chart that was developed. Who developed that summary chart?
So that was, again, as I mentioned earlier, I was unfortunately unable to pull anything from T-Mobile. I just could not get access. Then what I did is I logged into my personal Verizon phone records, and I was able to go back for 3 months. I couldn't get back to December, and then I downloaded the spreadsheets and I extracted those rows and provided that.
Did you provide the actual records or just the spreadsheet?
Well, I provided the spreadsheet, which was pulled from the records. I would have had to redact a lot of phone numbers if I was to put in the full extraction, if you will.
So you didn't provide the full extraction?
I provided the full extraction as it relates to all the contact between myself and Mr. Jackson and Miss Little.
Did you ever delete texts?
From last year?
Yes.
Yes.
After you had text messages with the defense, did you delete those texts?
After, I hung out with Karen Reed at the Omni Hotel and had drinks and dinner. My wife, my super fan wife, my murderer groupie wife, myself, also a murderer groupie.
Yeah, after the trial concluded, I mean, that's something I routinely do. I'm not going to keep texts from Mr. Jackson, especially now that we're past a year. I would have no reason to keep those, sir.
I'm not asking for the excuse. I'm asking if you did it. Did you delete texts?
Again, it's something that I typically do. I communicate with attorneys all the time, whether it's for trial or inspections. I don't have a habit of keeping a text chain about scheduling or meeting or, hey, can we meet at this time or show up here? I just don't have a habit of keeping that type of text. So he's not my friend, sir.
So you didn't delete texts?
I think I just told you that, yes, I did delete the text.
You didn't tell me, but you just did now. Thank you.
So next question, no
Okay.
comments, Mr. Brennan.
How many texts did you delete in communications with the defense?
I don't know the number, sir.
You don't know the number?
I don't have the text. So you're asking me over a year ago almost about text messages. I don't recall how many there were.
All right. Was there 10, 100, 1,000? How many were there?
Of ones that I sent?
No, not just what you sent. Either way, back and forth.
Probably, I don't know, maybe around 100 or so.
Right. So once the trial ended in a mistrial, I knew that the likelihood of me having to testify again with these same clients killer client is probably 100%. So I decided to delete those text messages. This is all the way Karen Reed's criminal defense team works. It's obscene. I mean, anyone who knows anything about the way lawyers work, expert witnesses work, this is so beyond the pale, out of the realm of normalcy.
And when did you delete those over 100 texts between you and the defense?
As I mentioned, I think the last text that I remember was Mr. Jackson texting me, just thanking me for my time coming up here after the trial. Again, that was at the end of June. And then I didn't hear from him. And at some point, I don't know specifically when, it would have been last year, but I deleted those texts. There was no reason for me to keep those, sir.
Do you remember about when you made the affirmative intentional effort to delete around 100 text messages between you and the defense?
It would have been sometime after the trial, probably before I got my new phone in November, but it would have been probably in the month or two after the trial. Sir.
Where were you when you were deleting this text? Were you at your office, at home? Do you remember sitting down and deciding intentionally you were going to delete over 100 texts? Where did that decision happen?
I have no idea, sir.
You can't remember deleting over 100 texts?
Sir, I just said I delete text routinely.
Right. I delete my emails routinely, but I remember where I am when I do it. And this, you would remember where you do it if you were deleting over 100 texts. Why wouldn't you just, I mean, it's so unbelievable. I just wiped them from my phone because I knew after I'd probably have to come back and testify again that I wouldn't need these communications. It's ridiculous. Ridiculous.
You're asking me to specifically give you a location at a time when I deleted those? I don't recall that.
You said it was after the trial?
Yes.
And out of the 100 texts or so, who were you texting on the defense team?
I believe it would have just been Mr. Jackson on that.
Did you ever communicate by any other means, like signal or an application?
During the time of the trial?
Anytime.
Yes, sir.
With the defense?
Yes.
Is it typical for a biomechanic?
All right. right. Thank you, Pat Brooks. That's very generous. Thank you, Roberta, for all you do. I could not watch this trial without you and this awesome community. It really is the most awesome chat. I know I'm biased, but I do think it is the most awesome chat. I also just want to take this time, a couple people to thank. I want to thank Jennifer Regan, Marcy Denton, Veda Setzer for her Venmo contributions. Appreciate it. It's a great way to support this channel. Send a donation via Venmo, buy me a coffee, or become a Patreon member and get access to exclusive content you won't find on the channel. All the links are in the description of this episode. Please hit the thumbs up while we're at this break. Thank you, Pat.
Mechanical engineer to use an application like Signal to talk to an attorney on a case?
Sure.
You know the benefit of Signal, don't you?
I mean, it's a messaging platform, yes.
Well, encrypted app, isn't it?
What was that?
Encrypted?
I don't know, sir.
It keeps no record of the communication when you use an application like Signal, does it?
I don't know, sir.
Well, you used it. Did you have it on your phone that you were using it with other people?
No, I don't believe so.
So the only time that you use Signal in your career is when you were dealing with this defense team?
Yes, it was earlier this year. Mr. Jackson had communicated with me, indicating that it was his preferred method of communication. So yes, we did exchange some messages on Signal. But this was at no point in time during the first trial.
Using the Signal app, was that your suggestion?
No, again, I think it was Mr. Jackson that said it was his preferred method.
Is that standard in your industry to use Signal when you're talking to clients?
I don't know that there's a standard out there, sir.
I'm asking about your standard.
Your standard. It's totally not standard, but it's the way criminal Karen Reed operates. That's how she talked to Aidan Kearney. She told Daniel Wolfe to download the app. She told the intermediary between herself and Aidan Kearney, Natalie Bernschneider-Wawicki, to download the same app. How much do you want to bet? Karen Reed is on the Signal group chat between Unetti, Elizabeth Little. I don't know if Robert Alessi was involved. If he was, sure Robert Alessi has downloaded Signal and is talking to them all, including Karen Reed on that app. I think that's a good bet. My money's on that.
Standard. Is it your standard to use an encrypted app when you're talking to attorneys?
If the client has that preference, I don't have a problem with it, sir.
How many times have you done it other than this defense team?
Again, as I just mentioned, it was the first time.
How many conversations do you think you had with the defense team by Signal?
Again, it would have been just Mr. Jackson. And like I said, it was really, I think, just in the month of March of this year, but it was brief. I know that I think we exchanged a couple phone calls, and I remember the call quality was terrible. So we really didn't use it that much.
Okay, you're saying a lot of things. You're saying you think. I want to know your best memory. I don't want you to think. You don't know, you don't know. How many times did you use Signal with the defense to talk about this case?
Going to allow it.
From what I recall, it was probably a handful of times.
When you say if what you recall, are you purposely being vague in case there's records, or do you not remember?
I don't remember, sir. As you mentioned, it doesn't keep a log of it, so I just don't recall.
Well, you don't have to rely on a log. You can rely on your actual memory.
Right. I'm telling you that I didn't keep track of it, so I don't know the specific number.
How many times do you think you talked by Signal?
As I just mentioned, I think it was a handful of times.
I don't know what a handful means.
Probably 4 to 5.
Well, was it 4 or was it 5?
It was probably 4 to 5. It's the best estimate I can give you.
How long were the conversations on Signal? The 4 to 5 times?
I think they were pretty brief. I'd say probably around 5 minutes or so.
You think each one was 5 minutes?
Probably 5 minutes,
Were
yes.
you putting it on a timer? Each one had to be a maximum of 5 minutes?
No, I'm just giving you my best estimate, sir.
How certain are you that the Signal calls were 4 to 5 minutes?
Again, I just told you I'm providing my best estimate.
How confident are you the times were between 4 and 5 minutes?
That's the best answer I can give you, sir. I'm giving you my best estimate.
I'm asking you how confident you are.
Answer that. How confident are you, Dr. Wolfe?
I can't answer that anymore.
Okay. When
Next
you were
question.
required by court order to provide all of the records to your honor, you knew that one of the important things you need to respond to were communications between you and the defense for her honor to consider, right?
Yes.
Okay. And signal is a communication, isn't it?
Certainly.
You looked at all your records and you knew it listed the text messages and the phone calls. You knew that, right?
Yes.
You knew that was going to be a representation that you were making to the court about your communications with the defense. You understood that, didn't you?
Yes, sir.
And you wouldn't want to mislead the court, would you?
No, which is why I told you.
I asked. You didn't put anywhere in your response to the court order that there were communications beyond text messages and phone calls. You never, ever alerted the court or anybody to that, did you?
Again, because I have no record of it. I have no way of being able to tell when those took place or how many there were.
The question I asked you is when you responded to the court order to provide all communications, and you responded by offering text messages and you responded by listing phone calls, you knew that your signal calls were communications, didn't you?
I provide everything that I had in my possession, sir.
That's not what I'm asking you. You knew the signal calls were communications, didn't you?
Yes.
Okay. And you never informed in your response that they were phone calls through signal as part of your communications, did you?
Again, because I didn't have any record like I do with the Verizon entries as well as the emails. I could not.
Right, because they asked me to put it on auto delete. So Signal has a option to put the text on auto delete, and that's the way it was on. That's the way they had him set it up. So now we think text messages are communications. Tell Robert Alessi, who said that they only thought that they meant by communications was emails. Give me a break. Tell me another one. Another judge would have just come down so hard on this defense team. But Judge Kearney, she'll allow it.
There's nothing I had in my possession, sir.
You've read this court order, haven't you?
Yes.
Did you understand when the court was looking for all communications, it meant all communications?
And I've provided everything that I have in my possession, sir.
During those 4 to 5 signal communications, did any of these occur before the end of the last trial?
I'm sorry, can you repeat that?
Did any of these signal communications happen before the end of the last trial?
No, like I said, they were all this year.
You sure about that?
Yes.
Now, at some point, did the defense send you a retainer agreement?
For this year?
Nope. Prior to the end of the last trial, did you ever get a retainer agreement?
No, there was no contract and retainer for the
Not
first
that there wasn't a contract. Did you ever receive a retainer agreement?
No, I don't believe so.
When you came out to the last voir dire and the last trial, did you have an agreement with any entity that was going to pay for your costs?
No, sir.
So you had no agreement that you were going to be refunded or compensated for your costs?
No.
Did you have any agreement that you were going to be compensated for your time?
No.
So when you were asked to come out and testify in this case, tell me, did you think that the defense was going to compensate you for the cost of you coming out here?
I had no idea who was ultimately going to pay the invoice, if an invoice was even sent.
Did you think that you were coming out here to testify for free?
Again, I don't know who was going to pay the bill.
That's not what I'm asking you. I want to know, after having these conversations with the defense, and they asked you to come out here, did you expect to be compensated for your time?
Again, I'm a salaried employee, so it doesn't matter to me. I'm sure my boss would like us to get paid, but no, I did not know ultimately who would pay an invoice if an invoice was sent after the trial.
Well, you were keeping track of your billing, weren't you?
I was keeping track of my time, yes.
And you kept track of your costs, didn't you?
The company does that, yes.
Did you?
Again, I enter my time so that the company can keep track of my time, yes.
When you came out here and made travel arrangements, did you have any conversations with anybody from the defense?
About the travel arrangements?
Yes.
Yes.
And as far as the travel arrangements, who on the defense was trying to help you with travel arrangements?
I believe it was Mr. Jackson.
Was there other people, associates, colleagues that were helping you as well?
None that I had direct communication with. I don't know if he communicated with others after that.
Was there a person named Kat? You ever hear that name before?
So Kat is a friend of Karen Reed's. You've also, the blonde woman, you've often seen her in the front row. She's also another childhood friend of, or went to school with Karen Reed. Hold on one sec. Her name is Catherine Quarantello. Let me see if I can get a picture for you guys. Bring it up, or a couple ones. And you'll definitely recognize her. So she's walking in the witnesses into court, the expert witnesses. Thanks for your patience. So here she is. And another shot. Which you'll probably recognize her better without the sunglasses. Sitting next to the glarer, the woman beater. A lot of people with criminal backgrounds in this case.
I believe that, yeah, she may have escorted me into the courtroom, I think.
Well, you don't believe, because that's a pretty particular name. So when you use words like you believe, you know. So did you meet a person by the name of Kat?
I'll allow it.
I think when I arrived here, yes.
Well, without qualification, the simple question is, you've met Kat, haven't you?
I think I met her. It was either at the voir dire day or the trial day. Yes.
Mm-hmm. Now, does Kat work for the defense?
I have no idea who she is.
Well, how did you know who she was? How was the introduction? How did that go down?
I just mentioned, I think she escorted me here to the courtroom.
Escorted you from where?
I think I drove here and I arrived, I believe, in the church parking lot across the street. And I think she walked me over. And then ultimately when I was done, I think she walked me back to the lot.
Did you have conversations with anybody from the defense about how you'd get here and why it is in particular you would park at the church parking lot?
Because I had no idea where to go.
But who told you where to go?
Right. Here's where he's not saying that he was told or he was following the trial and he knew that there was a buffer zone in place and he couldn't park right outside the courthouse and he would have to park in the church parking lot. He was following this whole trial. He was watching the whole thing. How does his wife join the Free Karen Read Facebook group and he doesn't know the significance of the church parking lot?
Like I mentioned, I communicated with Mr. Jackson, who provided that information to me.
And did you have any significance about the church parking lot? Did that mean anything to you?
No, he had just indicated, I think, that they had reserved it and it was a spot that I could park my vehicle.
Okay. And when you got there, did you meet with anybody from the defense?
I can't recall if they were standing out there and we walked in together. I don't recall.
I'm asking if you've met them, not whether you walked in together. I'll ask it again. When you arrived after these plans were made, did you meet with the defense before you came into court?
On the voir dire day, I don't believe, I can't recall if the defense was out there. I think on the day of trial, I think I met Mr. Jackson and maybe a couple of other members of the defense team.
Well, when you say you think, this was a pretty remarkable event coming to this trial, wasn't it?
I'll allow it.
Pretty remarkable event, this trial, wasn't it?
It's unique, yes.
Yeah, it's unique. And so when you came here, having had all these conversations with Attorney Jackson, you don't remember if you met him before you came in?
Okay, I will give him points for using unique correctly and not qualifying it. Excellent. Excellent points for using unique correctly.
Voir dire or came in for trial. You don't remember if you met him?
Well, like I said, I think for the voir dire, I think he was already, I believe, in the courthouse. So I think the first time I actually shook his hand and met him was the day of the trial, if I'm not mistaken.
Okay. And tell me, is that near the church parking lot that you met with them?
I'm sorry, what was your question?
Was it near the church parking lot where you met with them?
Yes.
Okay. You shook his hand. This is meeting face to face?
Yes.
Right? Yes?
Yes.
Did you have a conversation about the case?
I don't believe so, no.
When you say you don't believe so, do you think you had a conversation about the case?
At that point in time, no. I was getting ready to take the stand, so I don't think we had a conversation about it.
You were speaking to the defense or Attorney Jackson on June 10th, 2024. That was before your voir dire testimony, correct?
I believe so, yes.
And do you remember what those conversations were about?
I presume it was about the logistics of when we were needed. And then I know that ultimately I served as kind of the primary point of contact where I think Alan would reach out to me. he would give me some information about the scheduling and kind of when we would need it. Then I would check in with Dr. Rentschler, and then I would get back to Mr. Jackson. So there's kind of that channel of communication to try to figure out when we were to arrive and where we're supposed to go.
You're not saying that all your conversations with Alan were just logistics, were you?
I believe for the most part, yes.
So it took hundreds of texts, 100 texts for logistics?
Absolutely. I could certainly go into the day before my trial testimony, which was a very extensive travel day where I don't even think I left the Philadelphia airport.
We're going to get there, but there's a lot more communications before we get even close to that. Okay. Do you remember on June 10th having conversations with Attorney Jackson?
I do remember that there was conversations,
Okay.
yes.
Now, June 10th is 8 days before your testimony. Did you ever talk about an outline of your testimony or what your testimony would be?
No, sir.
You ultimately have more conversations on June 16th. Do you remember those conversations on June 16th?
Not specifically, no.
You don't remember them specifically? Do you remember whether or not you talked about the case with Attorney Jackson on June 16th?
We did not talk about the case, no.
Did you ever email with Attorney Jackson around that time?
In June 10th?
Before your voir dire?
I don't believe so, no.
So everything from your mind was just logistics at that point?
Yes, sir.
Okay. And then you came in for June 17th?
I believe the voir dire was the 18th.
Okay. Do you remember having phone calls on the 18th with Attorney Jackson?
The day of the voir dire?
Yes.
I could have to let him know that I arrived.
So you check in with a client, tell them you're on their way, even though you're not going to meet them?
To let them know that I'm coming to court?
Okay. And so when you testified in the voir dire, then did you have further conversations with Attorney Jackson?
After the voir dire?
Yeah.
Yes.
And did you talk about the case?
No, sir.
You had to testify, or you came and you testified on the 24th?
That sounds right.
You had a number of phone calls before the 24th. You had a series of phone calls on the 17th, 2 on the 18th, 2 on the 19th. Do you know what any of those were about?
I think it was about the logistics of arriving here because I know that I was going to, as opposed to driving, I know I was going to fly in this time.
Okay, how about the 21st and 23rd? There's a call on the 21st and 2 on the 23rd. Did you talk about the case?
No.
And so when you came into trial to testify, you were just relying on the opinions you had already provided in the past?
That were written in the February 12th report of 2024?
Yeah.
Yes.
And you had not talked about the case with Attorney Jackson or any member of this team?
No, it was all in the report, and that's ultimately what I testified exactly to at the time of trial in the voir dire, sir.
And you did not talk to Attorney Jackson or anybody else about the case?
No, sir.
May I approach?
Yes.
So if you're just tuning in, we're watching the ARCCA witness accident reconstructionists who were hired guns by Karen Reed's defense team, were paid $23,925. That's just the money we know about. They all deleted all their communications. Highly unusual in a trial like this. They communicated. I was joking. I've been joking that they were communicating on the Signal app. It turned out to be true. I mean, nothing's too outrageous for the facts of this case.
Jackson.
And do you recognize that?
Yes.
From you to who?
To Mr. Jackson.
And what's it labeled as?
Wolfe Direct.
And that's before you testified on trials, 24.
It's at 6 p.m. the night before I testified, yes.
So it's before you testified.
Yes.
Okay. Let me show you this document. You recognize that one?
Yes.
What's that?
That is the attachment to the email.
You recognize reading that?
Yes.
Do you recognize discussing the case before you testified on June 24, 2024?
I never discussed this with him. This is something that I sent to him, that I did on my own, and that I sent to him. But he never asked this of me, and we never discussed it.
So you sent him what you thought would be the best questions and answers that he asked you when you testified.
So this is something I routinely do when I work with attorneys, okay? I prepare this on my own to prep myself and prepare for trial.
Right. Of course you'd expect. This is what expert defense witnesses do. He's right here. But the public, what the public don't know about these expert witnesses, that they do this, that they are hired guns for the defense, that they craft their testimony to help get their criminal clients off. So what was so shocking about these communications was not that he suggested what he will and will not talk about, or how to counter a possible Commonwealth something that the Commonwealth will point out, that they never looked at the actual car or the actual location. It's that they were presented to the jury as independent, non-biased witnesses that could have been used by the Commonwealth, that had never talked to Yannetti or Jackson and weren't getting paid. That's the corruption. This is the real corruption in this trial and in this case. It's all coming from the defense. I mean, I've played this before, but I think it bears repeating. I think longtime viewers of my channel are going to know what I'm about to play. Here's Dominic Dunn talking about expert witnesses.
I only cover the trials of the rich, powerful, and famous because it is different for them than for other people, because they've got the bucks to spend on the $1 million lawyers, and they've got the bucks to bring in the expert witnesses. Jurors fall for those expert witnesses every time. I call them whores of the court because they can be bought by either side.
But they knew who they were, representing, which was they were going to represent what they had to do, and they knew they were out for Karen Reed. And strangely, the Attorney General's office was doing a favor for Karen Reed. Now, we know Yannetti helped with Rachel Rollins, who worked at the Attorney General's office on her team, big innocence fraudster lawyer. Got a guy out who reoffended, killed 2 men. He got convicted twice. Then his conviction got confirmed by the highest courts, an appeal after appeal. The Innocence Project overturns his conviction, and he just reoffended, high on substances, on rock Pepsi, let's put it that way, found with a gun and evaded arrest, ran his car into a nursery school. Ronnie Quayles, if you want to look it up, went over it last night. So that's what Rachel Rollins, the Attorney General's office, was involved in, and Yannetti was involved in her transition team. So he had ties to the Attorney General's office. And they're the ones who agreed to do an investigation into Karen Reed's case.
There's an email with a document I'd like to attach as an exhibit.
Okay. Exhibit 1. 1.
So you assisted the defense before your testimony.
Hold on.
Thank you. So you assisted the defense in anticipation of your testimony by sharing with them the questions and answers you thought would be most helpful.
Again, as I mentioned, this is something that I do internally to prepare. I sent that to him the evening before I testified at 6 p.m. I presume that he already had his direct examination done at that point. So I sent that to him, yes.
That's a lot of answers other than the one for my question. The one for my question.
Hold the comments, please.
So my question was, you had communications offering information to the defense before you testified in a way that you thought would help the testimony, didn't you?
Well, first off, I have no idea if he even read it or utilized anything from it.
But that's not really answering the question I just asked, is it?
Can you repeat the question?
Of course I can. So when you sent a direct examination to Attorney Jackson before your testimony, you communicated with Attorney Jackson, providing information that you thought would best help your testimony.
Oh, Allison Galvani from My Father's Alibi. So nice to see you. Hope you're doing well. I appreciate you, Allison. She says, appreciate Roberta, Maestro, and this wonderful community they foster. Thanks so much. That's so kind. Doobly-doo is saying Court TV keeps saying if the report favored the Commonwealth, Brennan wouldn't be complaining. Okay, let's talk about that for a second. Let's talk about ARCCA as independent witnesses. Now, they were given information cherry-picked by the defense. They say the feds, but it's really hard to tell the difference between the feds and the defense. And they testified in trial that if they got more information, it wouldn't change their opinion. You know, if I got more information in this case, besides why comes they got rid of their phones? Why come butt dials that we don't even know if they connected or not? Can they think of any other reason for those things to happen besides murder? I will tell you that if I were involved with Karen Reed as a witness, I would absolutely, if they told me it was okay, get rid of my phone, throw it into a volcano if I had to. Not that I think that there's anything particularly incriminating on my phone. There might be selfies I don't want out there, because if something doesn't make it look good for me, that Karen Reed's going to put it all, and Turtle Boy is going to blast it all over social media. Karen Reed was a Facebook stalker. She utilized Facebook like no other. That is Natalie Bernschneider-Wawicki, the intermediary between Karen Reed and Aidan Turtle Boy Kearney. So yeah, privacy reasons, other reasons. Why don't the free Karen Readers ask themselves why Karen Reed lies so much? Why her stories change all the time? Why her car reversed 24 miles an hour with her foot 75% on the pedal? Why microscopic pieces of her taillight were found embedded in John O'Keefe's shirt? How the taillight was planted. We claim the taillight is planted. How is it planted when the SIR team had arrived when the car was already on the way to the Sallyport? There's just no way that this can be done. Your conspiracy can come true using all the evidence. It doesn't fit. You know what fits perfectly? Karen Reed running over John O'Keefe in her vehicle, going 24 miles an hour in reverse. Her foot 75% down on the gas pedal. All right, 74.5. I'm rounding up. With her infotainment system beeping and flashing at her. You know what? Oh, you know what? I buried the lead. Guys. I buried the lead. You know what else we found out today in court? Big shocker. McNasty Green, Richard Green, Karen Reed's forensic examiner, called Cellebrite to figure out the information. Couldn't read the phone extraction. What an expert. These are just bottom of the barrel people on the downward slide of life besides ARCCA. Let's look at her McNasty Green. He's got a criminal record. Marie Russell's gotten fired, made her way from the coroner's office, from an EMT to the coroner's office to a jail, to being a doctor in prison. That's like really low on the totem pole. She's been retired for years and is a true crime fan and a dark personality herself with a hobby in dog bites, who says she's seen hundreds of thousands of dog bites. Hundreds of thousands of dog bites in the EMT. Come on. Come on. And she's the best expert in the world. Anybody remember Marie Russell, their other expert witness in this case?
Bored and retired, threw myself into a high-profile trial, thirsty for attention and admiration. I'm the best expert in the entire nation. Get paid to lie by the hour, making stuff up is my superpower. I see dog bites. I see dog bites. Just pay me and I'll tell you they are dog bites. Limp to the stand, decked out in polyester. Lay my lies on the court and let them fester. Puncture wounds in the shirt. Testified to a great deal, I'm certain. Hell, they'll say anything. It's the prosecution that's got the burden. I'm the best expert that's ever been. Who else can testify to a dog bite by a canine without a chin? Don't need evidence to state my claims. There's a lot of hounds in the world. One's got to be blamed. I'll do anything to get rich and get off killers. Pay me extra, I'll blame gorillas.
Okay. That's Marie Russell, for those that you have forgotten.
Only in court.
Well, I think ultimately it's to help the jury understand my report and my analysis.
Do you think it's helpful not answering the question and just diverting every time I ask you something? Do you think that's helpful? Do you want to answer my question or do you want me to move on?
I think I answered your question.
I don't think you did, so I'll ask it one more time.
All right, no.
What dark things are in this guy's past? I want to know.
Comments, please.
Do you think that providing a direct examination to the defense before you testify is in any way assisting preparing for your testimony?
Again, I don't know if he even utilized it, sir. And certainly if the Commonwealth had reached out, they could have gotten a copy of that as well. It would have been the same exact outline whether I testified on behalf of the defense or behalf of the Commonwealth.
You don't want to answer my question? Did you ever make any comments?
Okay, there's another scripted lie by the defense. So you guys get the idea. I think this is a good place to end it for today. You get the idea, you get the idea, you get the idea, you get the idea. Yeah. Oh, I'd say the exact same thing. No matter who paid me, give me a break. Tell me another one. Were we all just born yesterday? Were we all just born yesterday? All right. All right. I'll see you guys tomorrow at 9 a.m. I appreciate everyone who's watching this trial with me. Please hit the thumbs up on your way out. Share this episode. Leave me a comment. I read every single one of your comments. Really enjoy them. Get a lot out of them. Support the channel via Venmo, buy me a coffee, or become a Patreon member. Get access to content that is exclusive. Be back tomorrow at 9 a.m. right here on this channel. And then I'll see you again at 6. All right. Have a great night, everyone. Thanks for listening. The links are in the episode description. Did I say that? I don't know. Thank you. Thank you, Maestro. The links are in the description. Have a great night, everybody.
I hit my boyfriend with my car. It wasn't an accident, but with lying lawyers I'll go far. lying lawyers, and witness harassment. I'll avoid prison, it was snowing. I pushed the pedal down, hit him hard. Now the legal system I clown. Innocence fraud campaign to save my skin. Making money, truth is my second victim. Carry, carry, Jen, Jen, like John, you were my mark. My innocence fraud campaign is my biggest hit. Hit. I hit my boyfriend with my car. It wasn't an accident, but with lying lawyers I'll go far. Lying lawyers and witness harassment. I'll avoid prison, it was snowing. I pushed the pedal down, hit him hard. Now the legal system I clown.